Good morning, everyone. We're just getting settled up here, ready to start the second panel session of the day. Welcome to Rudnick's third litigation conference, and the message from the first session was really make PACCAR history from Susan Dunn. And there's been some fantastic work, obviously, behind the scenes over the last 8 months or so to make that happen. This second panel session is looking, however, at the UK group action landscape since PACCAR and the fallout of that decision and how funders, counsel, legal teams on the ground have been grappling with some of the issues that has thrown up. I'm Tom McDonnell. I'm counsel in Rudnick's litigation team, and delighted to be joined by this panel and introduce themselves shortly to discuss a range of topics from the last 8 months or so, which have been significant for the group action and litigation funding market. Although we all live it, and many of us love it, litigation funding doesn't always make it into the headline news. That's hard to believe, I know. But the last 8 months has certainly been an exception to that. From the PACCAR decision in late July 2023, just as everyone was about to go on summer holiday, through to the renewed focus on the post office scandal and the group claim on behalf of postmasters 5 years ago, it has been an extremely busy few months in the group litigation space. It is also a period in which there were several court decisions in the securities litigation space as parties continue to dispute the most effective way to pursue securities litigation claims through the courts, given their size, given the issues at play. And we also sensed, on the Rudnick side at least, and this was mentioned on the previous panel briefly, an uptick in the interest in funding law firms themselves rather than the underlying actions. So that's a very broad overview of some of the issues that we're going to cover on today's panel. And if I just could ask each of the panel members to introduce themselves, starting with Neil.
Yes, I'm Neil Purslow. I'm a founder and the Chief Investment Officer for Therium Capital Management.
Charlie Morris, Chief Investment Officer for Woodsford, which is a collective redress and litigation finance business that funds a lot of the securities actions that Tom was talking about.
Nicholas Bacon, 4 New Square, counsel, been fortunate enough to be involved in a lot of litigation funding cases on both sides, and I've been involved, as many of you know, in the reforms that have been taking place over the last decade too, and continue to be so.
My name's Alex Garnier. I'm a founding partner and the portfolio manager at NorthWall Capital. We're a private capital firm focused on private credit and legal assets, primarily in Europe, but also in the US.
Thank you very much, and thank you for being with us today. I just wanted to start by reflecting on the group action against the post office. Because that has dominated the headlines really since the beginning of 2024. And we have the honour of being joined by Neil from Therium, who funded the claim against the post office. And it would be really good, Neil, to start with, to get your reflections on that case 5 years on, and in light of the publicity in recent months.
Sure, Tom, I mean, you're right. There's been an extraordinary degree of coverage of this case in the last few months since the ITV drama came out in January. I don't think we've ever seen a funded case certainly cut through like this into the public awareness, and you have to pinch yourself slightly when you're hearing people talking about funding and PACCAR issues on podcasts like The Rest is Politics. So this is a sort of level of exposure I don't think we've ever seen before. But it's completely right that the case has attracted so much attention. It's been widely described as the widest miscarriage of justice in British legal history, and had an enormous effect, enormously detrimental effect on the individuals concerned, and has led to a 20-year struggle for justice on behalf of the postmasters, of which the civil litigation was only a very small part of that period. And that story hasn't fully been told in the drama. The drama focuses on certain parts of it, but doesn't really show the campaign that Alan Bates and others led. And it's, I think, a testament to Alan Bates and the others' their tenacity and I think their decency that they've managed to get themselves to the point they are at the moment, where they're now potentially having a solution in prospect. But I think it's worth remembering in this case that they haven't actually received justice yet. So most of the wrongful convictions still haven't been overturned, and most of them haven't received the redress that they're owed. So this is still very much a live issue. The civil litigation, though, ran from sort of 2015, 2016, started in 2016 and settled at the end of 2019, so it only plays a role, a partial role, and the solution obviously to the overall thing now will be political, but the civil litigation was absolutely pivotal in enabling the postmasters to get justice. And the reason for that is because it was the litigation that proved that what they were saying was that they were telling the truth, and that the post office had been lying basically to them for the whole period of time. So it turned that direction. It led, of course, to public inquiries, it led to redress schemes, it led to the drama, and is now leading to the legislation. So without that litigation, they wouldn't be where they are today. It's also right to say that that litigation wouldn't have happened without funding. Again, a very high-profile example of that. And it's, I think, a fantastic proof point for the industry to be able to point to an example of a case with this sort of driver to it. We can say and show the very positive effect that funding has managed to achieve. Now, fair civil justice would have us believe that the claimants didn't get enough out of this case, and therefore the funding return should be capped. That argument is obviously nonsense. What they are suggesting is that if the claimants don't get enough, they should get nothing, because they would have no access to justice whatsoever. And that clearly isn't the right thing, and that ignores the fact also in this case that there weren't just civil damages in play, but there's also the truth underneath it and the overturning of the wrongful convictions. So I would call them out on that. There's also, I think, been some misreporting about this case as well, and it's been said that the funder's return was 80% of the damages. That's not correct. The funder's return was 41% of the damages. And that number, of course, we'll all realise, would be within the cap on percentages which the DBA regs would have allowed. So that if we had a cap, then it might well have been okay in this situation. The problem in the case came from the very high legal costs, and those were very high legal costs that were caused by the way in which the Post Office ran the litigation, what was the judge described as their flat earth approach to the case. Meeting that led the claimants to have to upsize twice. The overall costs were 3 times their original budget. That of course puts huge strain on the economics of the case, and the Post Office would have been well aware drives claimants towards settling at a lower number than they should otherwise get. Against that, the Post Office spent twice what the claimants spent on their legal costs, and that's bearing in mind their buying power as the organisation the size they are. They also spent more than they spent on the settlement, on the damages that they paid to the postmasters, plus of course the contribution they paid to the postmasters' costs. So they paid 100 million in overall. Now, had that 100 million been applied at the outset of the case, and bear in mind the Post Office could do this because there had been a mediation scheme in place before, the claimants would have received 9 times more in compensation than they got from the litigation, and they would have been compensated 8 years earlier. So this is a great example of a defendant spending money on lawyers rather than doing the right thing. Of course, the public purse is picking up that bill. Ultimately, we are. And there will be no doubt questions as to how this came about, and rightly so. So, unfortunately, this approach is not unusual. We see a scorched earth approach to litigation all the time, and we see a scorched earth approach to litigation all the time, and we see defendants running up costs in order to put pressure on claimants and turn the litigation into a zero-sum game. So what we need is a rule change which allows in certain cases the courts to make the defendants liable for the funding cost. What this would do is take away the benefit to the defendants of running this kind of strategy, and it would protect the claimant's recovery. Now, the Post Office case is a paradigm example of a case where this should have happened. You had a huge inequality of arms between the Post Office on the one side, a public-backed company, and the individual claimants. You had the individual postmasters' impecuniosity caused by the defendant, and you had the unreasonable litigation conduct of the Post Office driving up costs. So if we do get to a review of litigation funding, I hope that this will be a central issue in the debate.
Thank you. Just to open that up to the panel and for your any observations that you had on the Post Office case, and particularly, I suppose, Neil's point at the end there about defendants facing up to the consequences of running up costs through their scorched earth policies. It would be interesting to hear the panel's views.
The first panel mentioned a case called SR, which was SR in Northcott, which Woodsford funded, and the decision came down around 2016 that the defendant's conduct had forced Northcott into an impecunious situation where it had no choice other than to obtain funding to pursue the case. And so the arbitrator allowed the recovery of the 3 times return that was due to Woodsford in that case, and that was upheld on appeal by the High Court. And a lot of the circumstances that Neil just described in the Post Office were entirely applicable there as well. And so I fully echo Neil's views that there needs to be a focus not so much on how much the funder took from the entire damages sum, but more on putting the claimants back into the situation that they ought to have been in but for the defendant's misconduct. And it's not, these 2 cases aren't unusual. Across all of the cases that Woodsford funds, the defendant misconduct has been egregious, and so many of them would be suitable for this kind of recovery in our view. And in the pre-2013, pre-Jackson era, where ATE premia and CFA success fees were recoverable, part of the problem was that was, I think, a mandated situation. So as long as you gave notice of the additional liability to the defendant had to pay it. And that was considered to be unfair on defendants, and so it was all rowed back in the Jackson reforms. I think the solution is for the court to have a power to order this, but not necessarily to exercise it in every case, but to look at the factual situation from case to case and decide whether it's appropriate or not. And hopefully that would have the effect on these defendants of conducting litigation in a proper and sensible manner, and not just throwing as much resource at the legal team as possible to try and win the claim on anything other than the substance of it.
What are some of the tactics, Charlie, that you've seen, just to put you on the spot, what are some of the tactics that defendants tend to roll out? Well,
so the most obvious one for today's audience is an attack on the funding. That's nothing to do with the substance of the claim, whether it's meritorious or not, but to take out the building blocks behind the claim and to hobble it at source. But that is a common defendant tactic that we see across UK group actions, even though there's no entitlement on the part of the defendants to know what the funding arrangements are outside of the CAT opt-out space. They nonetheless press for it, propose that they might bring security for costs applications. All of that is targeted less at securing something for their costs in case they win, and more at trying to stymie the claim.
Yeah. Nick, it'd be good to get your views on the Post Office and the fallout.
Yeah, I mean, in terms of where we've ended up with the irrecoverability of funding costs, I do share some sympathy there. I mean, I was lucky enough to be instructed in that SR case, and it's a pretty significant decision where, as Charlie was saying, we recovered the funding costs with bells and whistles, and the High Court, looking at the jurisdiction in the arbitration world, upheld the judgment and upheld the decision, and it was essentially based on what is fair and what the just result was. That's what underpinned it. And yet when you come to the civil litigation world, we've ended up in a situation where the law simply doesn't permit its recovery, and as Neil was saying, we will have to have a rule change, statutory change probably, to enable that to happen, if that's going to happen. I mean, to my mind, one of the problems with the sort of recoverability of costs market is it's often driven by different interests. I mean, the Jackson reforms and the removal of recoverable success fees and ATE premiums was driven, to my mind, based on my own experience, by the personal injury market, actually. And it was driven by the reluctance, the frustration on the behalf of road traffic insurers, people who we pay our premiums to drive our cars around, that were ending up paying substantial costs in claims brought for personal injury, which sometimes doubled the cost exposure because there was a 100% success fee and there was an 80 premium on top, and it was worth hundreds and hundreds of millions of pounds, if not more, going forward through the years ahead. And so the government was persuaded by that pressure group, I think, to look at removing the ability to recover success fees and ATE, which had hitherto been seen as an access to justice point. So and as a consequence of that, you can't recover funding in all cases, not just personal injury and road traffic type cases. And that, I think, is a problem. It's too broad brush, and I would have thought there's room for government to look at a more sort of forensic analysis of where costs funding should and shouldn't be recoverable. But as I say, that I think Section 51, which is of the Senior Courts Act, probably requires amending. But we know from the work that others are doing in PACCAR that governments can change the law, and I can see the force of that.
And Alex, your views on the fallout post office?
Well, clearly I agree with the panelists that having a system which means that it might make sense for a defendant to run up costs and funding costs on the claimant side creates perverse incentives, and really what you want is to level the playing field so that it's all about the legal merits rather than the stamina and how deep-pocketed either side is. I think more important from our perspective, from a funder's perspective, is having certainty around what the position is. So PACCAR is a good example of that, and I think we'll talk about that next. But one of the reasons we're in the English courts is because of the perceived reliability of the legal, regulatory, political framework. And one thing we've learned from recent years is to expect the unexpected, and the PACCAR decision is just another element of that. I do think bringing this into the public sphere is only a good thing, whatever results from it. There may be some positive developments, there may be some negative developments for the funding industry around capping of what's allowed to be charged. But the sooner we have clarity, the better, and then people can analyse risk, reward, and structure around that.
A striking feature of the Post Office case for me in watching the drama earlier this year was the challenge that the postmasters seemed to have in finding a legal team and finding litigation funders. And so it's quite an odd coincidence that the focus shifted back to the Post Office this year, publicly at least, just at the same time that the PACCAR decision had come in and had threatened the availability of litigation funding to individuals like the postmasters. Nick, it'd be good to get your overview of some of the issues that the parties have been grappling with in litigation following the PACCAR decision.
Oh, how long have you got? I mean, it's
36 minutes.
Yeah, it was. The dissenting judgment is a remarkable, correct, to my mind, analysis of the legal framework, and I'm afraid, I think that decision is regrettable, to say the least. But we have it. It is our Supreme Court telling us that litigation funding was a species of claims management, and the terms upon which the funding agreements were agreed, namely a percentage of the recoveries, meant that they had to comply with the damages-based agreement regulations. Something, as many of you will know, Rachel, who spoke earlier, and I had foreseen in proposed draft amendment regulations which would have avoided the entirety of PACCAR, but the government has been so slow to engage that those regulations were never introduced, but if they had been, as I say, we wouldn't be where we are today. The really good news is that, it sounds as though this is all going to be put right, and I agree respectively with Sue. I think it should just be a small footnote, footnote 6. It's a blip in the landscape, which hopefully that's how it will be perceived. But to answer the question, the fallout has been, extraordinary. I mean, I never work during August, but I worked during August. I mean, it was,
Shocking.
Practical things like, amending agreements. That was. I mean, amending the agreements per se was not too difficult, but it led, as I think Charlie indicated to, or somebody indicated earlier, to, the funded parties then taking the chance of renegotiating the terms. If you're going to change this, then we want to change this, and it became difficult. And I was always of the view that whatever happened, during this period, it's so important for the funding market and the legal teams involved and the class reps and the clients who are being funded to just maintain stability and not fall out, because as soon as there were fallouts, then the whole thing could become very, very messy. But I think overall, in my experience, there's been a real sense of, community on that aspect, which has led to sensible resolutions to the amendments of agreements. We've got to the point where, to avoid the PACCAR judgment and its implications, funders have agreed sensibly to agree to multiples. There's still no certainty there, but the CAT, certainly, who's taking a lead on these cases because they look at them, have so far been supporting of multiples falling outside of the DBA regulations. We've had Sony and so on. They're all going on appeal, but hopefully if we get amendments to the statutory regime, those appeals will just fall away. And certainly, in my experience of being in these cases, the defendants are less charged up by challenging funding agreements. I hope that's a fair reflection of what's going on. They seem to be saying, we'll just wait and see. So I'm optimistic about all this, really optimistic that it's just going to be a blip, and we'll look back on it saying what a nightmare it was, but actually it didn't really achieve a great deal. But the fact that the industry has worked its way through it and come out the other side is a credit to the industry. I think also, in one sense, ironically perhaps, PACCAR, alongside the Post Office, has brought a positive to the funding world. People now know about it. I mean, it's out there, and obviously you people know about it, but there's a lot of people that don't, that now do, and so that's a positive from a negative.
And how about experience through the courts of tactics that defendants have taken? Is your experience that they've tried to take advantage of this period, or?
Oh, absolutely, yeah. I mean, August was not filled with just redrafting. It was filled with defending, writing letters back to claimants saying, we're still good, and this case is not going to be struck out. Yeah, but the defendants, I act for both sides, so I don't take a side here, but it's right to say that naturally, if there's a chink in the armour somewhere, and the defendants have got the cash to spend, they will exploit the chink. There's no question about that.
I don't think there needs to be a chink.
They will certainly exploit the chink, and that's to be expected. That's what happens in litigation, right? I mean, that's what happens, and you can't stop that happening. And I think the judiciary will determine cases and as and when they come before it. There are disclosure applications and security for cost applications going on, but they're just all going to have to be resolved separately on their facts individually. And I'm not sure there's a great deal one can do about it. It's part of life's richness on the litigation field. I'd be surprised if you get a law that says thou shalt not ever seek security for costs against a funder. There's a law that says you can. So it will happen. It's just that the market needs to price in these bumps on the road. So I think overall, though, from the CAT's perspective, sorry to go on, but I think, we could be sitting here in a different environment. I mean, the CAT, I think, has been very supportive, actually, of litigation funding. They have said in every significant judgment how important litigation funding is to the operation of the CAT. I mean, without funding, they may as well close the doors. You can't bring a claim, an opt-out claim, and opt-in claims too, but certainly opt-out, without any funding. And so at one stage with this decision, the PACCAR, the doors would literally close on the opt-out scheme. So they've been very positive, and I think also the senior judiciary recognise the important role that litigation funders play in our world, and they support that. So that's a good thing. We could be sitting here with a judiciary that doesn't think like that, and we're not.
So Nick was working hard in August. I imagine each of the three of you were as well, and it would be good just to get your take on what was going on sort of on the ground, on the funder side during that period, starting with you, Charlie.
Yeah, I mean, Woodsford is funding the case against Sony, and Sony seems to be leading the defendant charge on all of this. The arguments are terrible, very spurious, but made nonetheless. And yes, I was working during August to try and fix the funding agreements, and one of the things that we came up with was introducing conditionality before the percentage clause rather than removing it entirely. And that was with one eye on the law hopefully changing, which it now looks like it might. But nonetheless, the challenge continues, and I think the point was made on the first panel this morning that it's a complete waste of court time at the moment and taxpayers' money that we're going through the CAT on all of these challenges, with each defendant making the same arguments again and again, the CAT deciding the same way again and again, and then it goes up to the Court of Appeal, and the Court of Appeal, which is very busy, is going to have to decide this issue. All of it might become completely moot if the government gets its act together and changes the law. But just for a practical perspective, it did distract us from our ordinary business, having to revisit all of these arrangements. And in the UK group action space, because so much of it is opt-in, and because you tend to have a finance agreement in place with every single claimant, it would be a logistical nightmare to have to effectively go through the process of revising all of those agreements. We are hoping that the law will change before we have to embark on that exercise, which would otherwise be a complete waste of time. And in the meantime, the CAT has helpfully indicated that severance provisions in these agreements can be relied upon to just chop the percentage provision to the extent there is one, and leave behind the multiple to the extent there is one. And so we have done it on a as needed basis. Obviously this issue only comes to light as you reach the point of resolution of the action, and some of our actions are further away from resolution than others. So it's been a busy period, and ultimately it will hopefully prove to be a footnote and a complete waste of time as well.
And Alex, from your perspective, what's the last 8 months been like?
From our perspective, I think the key point really is that it's added another variable, another level of uncertainty in this asset class, and risk, or the perception of additional risk, results in a number of different things. First of all, people expect higher returns in comparison to other asset classes that might be perceived as more stable. Second of all, structuring becomes even more important. We're very much focused on funding portfolios of claims, whether that's via law firm loans or acquiring and funding portfolios, which diversifies your risk across a number of different factors, defendants, maybe even jurisdictions, and also spreads the duration of the different investments you're investing in. And then thirdly, I think the important factor is, certainly from a claimant perspective, picking and choosing who you get into bed with. We are lucky enough to, in the main, work with very established reliable, long-term partners that are probably not going to look for loopholes in our agreements. Clearly the situation is different if you're in a sort of a Bugsby type situation where the money has come in as compared to where funding is still remaining to be dispersed, and that's an easier conversation to have. Fortunately for us, all of our conversations fell into that sphere. Maybe Neil can tell us how the arbitration is going in that case. But I think our focus on those things is even greater than it was before. In terms of the structure, we've always had a multiple-based approach, frankly, so we're a little bit less concerned about that. The Sony situation, and whether it's predicated on whether the new formulations are predicated on a share of damages being legal, or whether you have an alternative, looks like it's going to be moot if Alex Chalk is to be believed. So we're slightly less concerned about that. But we take on board the reminder that, again, we should expect the unexpected, and plan for the worst by diversifying, by having other protections, such as, for example, when you're funding corporate claimants, you can look for cross-collateralization over other assets or even cash, in the event that things don't work out. It's good food for thought. And then one final point, I think, we are London-based. We know this jurisdiction very well. I think one thing that it has done is made people more nervous about investing over in Europe, in the UK, in England, because actually they realized that some of these risks that were perceived to be emerging market risks, such as regulatory, legal, political changes, are actually things that might pop up at home as well. We have, I think, as somebody said on the first panel, a strong and very experienced judiciary, which is of course incorruptible, but nevertheless, things happen that you don't expect.
And what are the alternative or the diversifications that you've pursued in recent years is the law firm funding aspect, and did you find that was fairly protected from the PACCAR fallout?
Well, actually, that structure is protected in any event, because if you have a loan to a law firm or some kind of funding arrangement with a law firm, then actually underlying that you will have CFAs and DBAs, which should work. Obviously, if you're putting in place a litigation funding agreement, then you fall into this question of whether that's a DBA or not. So I think that's a safer means of investing in any event. If you are investing in a portfolio of cases or a portfolio of LFAs, then a bit of diversity is clearly helpful. You might have some earlier stage litigations, some later stage litigations. You might have claimants that have a propensity to settle versus those that want to string it out. You might be in other jurisdictions in continental Europe or in the US, wherever it might be, as opposed to in England. You're unlikely to see this issue crop up in the entirety of your exposure, but rather a small portion of it. Just good portfolio management.
Neil, we couldn't get through the panel session without mentioning Bugsby, so it'd be interesting to hear how Therium have been dealing with the fallout over the last 8 months.
Yeah, so I was on holiday when PACCAR came out, and the only good thing I can say about that is if you must deal with PACCAR, it's better to do it in Bali. Because we'd been involved in it, we had to some extent anticipated that the decision would come out and could be negative. You could see that in the body language of the judges in the Supreme Court. And so we were to some extent prepared, and were able to do a kind of very quick review of the book and be able to start work on how we're going to manage this out and get the necessary advice and so on. So we were quick to it, and I think that was important because maintaining investor confidence around it and maintaining we had our arms around the problem, I think, was a very important component of how we dealt with it. And for the most part, we were able, or have been able, to renegotiate funding agreements. The irony of it is, of course, we've renegotiated them onto multiple basis only, and query whether that's actually in the better interests of the claimants, who were the ones who were supposed to be protected by this stupid regulation. Because obviously, in some cases, it's meant higher multiples to compensate for giving up the percentage, which gives you a higher priority position, which isn't necessarily good if you get a low result from the claimant's point of view. So I don't think there's been any public policy benefit whatsoever to the imposition of this on us. But there it is. There are cases that we found that difficult to do. Usually those have been ones where the percentage was of the greatest value, and therefore that issue was most contentious. But another one was, of course, the Bugsby case, which would be a good example of the sort of crap that Susan said that we must deal with as an industry. A case that had settled or was about to settle. We'd had a decision and there was an opportunity to settle it that came around after PACCAR decision was handed down, and so the client was able to opportunistically try to take advantage of PACCAR. That, of course, we had to move very quickly on that in order to be able to preserve the cash, hence the reason for the asset preservation orders, and the court has been very supportive of us on that, which has been fantastic. And I think I agree with Nick that the general sense we've had from the judiciary in lots of different ways here has been broadly positive and broadly supportive, and helping us hold the ring while we deal with it. The one thing I think I'd take away from it, and this is, by the way, going to be a plug for ILFA, is how the industry has come together to deal with it. It would not have been possible, I think, for any individual funder to be able to try to address this issue and be successful in getting the government to deal with it and to legislate in primary legislation. When we started looking at it and started talking to MOJ's view was primary legislation. No chance, you're looking at years. But now we're in a situation where, hopefully, fingers crossed, we're on the cusp of being able to get that done. And that is, I think, because we have funders working together, collaborating, sharing knowledge, sharing ideas, sharing resources, and sharing also case studies and examples and pooling resource. All of that only happens because of organisations like ALF and ILFA. The PACCAR, I think, is an example of really the value of that kind of coordination, and it was necessary that we were coordinated before and knew how to work together before this then hit. So
that brings us on quite nicely to just taking the panel's reaction to the recent announcement a couple of weeks ago to introduce new legislation to address the impacts of PACCAR, to improve access to justice through litigation funding, and also to conduct a review of the litigation funding market. No real further detail provided as yet, but just to get your reaction to that, starting with Mick.
Well, as I say, it's great news. I mean, when I heard that the government was actually going to introduce some legislation specifically for PACCAR and to resolve it and put it all right retrospectively, it was great news, because the messages and signals with disputes and arguments over title and the DBT, it was all getting pretty depressing over Christmas time, certainly. But as Susan said, and as we're all probably thinking, it until it's signed off and until it actually happens, we have the prospect of the Supreme Court looking at multiples, on appeals from the Court of Appeal, and we've just got that. Just can't happen. This has got to be changed, and I just hope that there is the willingness there to get it changed. I don't know the detail, but I think keeping it really simple and leaving aside regulation, just sorting out PACCAR with a one-line amendment, to my mind, to Section 58, or to exclude litigation funding from claims management services. Something very simple is required, because as soon as you start sort of tagging in requirements and things like that, I think you'll end up in a world of disagreement between different vociferous, outspoken organisations, and then you won't get reform. So I hope that's the focus. But it sounds like that's the way it's heading. But as I say, I think as Sue says, until you get it signed off, we don't have it. That's the thing.
I think it's unfortunate that this has given an opportunity to the anti-litigation funding lobbyists to push for reform and regulation. It's something, Woodsford funds across jurisdictions. It's something that I have dealt with in the last 4 years in Australia, which was a very politically motivated, big business lobby-driven introduction of hopeless regulation that was peeled back as soon as the Labour government in Australia was elected. It was a complete waste of everyone's time, and it tried, the former government, to introduce things like a 30% cap. Because there were a lot of people involved who didn't really understand what that meant. And Susan was absolutely right when she said what it will mean in practice is that lots of very meritorious actions won't be funded and pursued. But people who are against our industry will see any opportunity, maybe a chink, maybe no chink at all, to make their points and try and shut down these actions that seek to hold them to account, because they don't like being held to account.
And Alex, your views on that?
Well, just to take the other side of that, I don't think it's necessarily a bad thing to have a clear framework which sets out a cap of some description. I think clearly there are situations where claimants who may not be corporates but individuals who are seeking justice are left with very little at the end of the day in the pot. Now, primarily that may be the result of defendants stringing it out and causing those costs to rack up. But in any event, that result isn't a very attractive one, and I'm not really sure it helps the industry to have those figures bandied about. So I would welcome clarity, even if it involves some kind of regime to cap the amount of damages. I think my suspicion is, based on some of the announcements we've seen from the government, that they may try and tie other elements into this rather than have just a simple one-line amendment, which would clearly be the most helpful for us to move on with our lives. But my suspicion is they'll try and do something. I think just one other thing to mention is it does create opportunities for investors who have more confidence or more stamina to get involved in some of these situations in satellite litigation. There may be situations where people want to get out because of the uncertainty, and there is a healthy secondary market where people might start investing in those litigations that have an element of risk involved because of the legislative uncertainty.
Just to be clear, I'm not against there being rules around how litigation funders conduct themselves. We already are regulated, we're self-regulated, and we operate in a highly scrutinised environment where we deal with regulated solicitors. All of our matters are typically before tribunals and courts who have oversight of what's going on. So this is not an attempt to escape rules around how we should conduct ourselves. We do that already. It's an attempt to not have ill-fitting external regulation just because there's a clamour for it from entities on defendant side.
Yeah, I've got 2 points. So one, in terms of PACCAR is PACCAR. As soon as you start introducing potential consultation on caps and things, it just won't happen. I mean, just my own experience in Civil Procedure Rules Committee, getting changes through Parliament, the more you end up trying to do, the longer the consultation, the more interested groups that get involved, and the longer it takes. And so whoever's involved in all this, you've got to keep it really focused on just a simple amendment to the legislation, and then deal with regulation and caps and all the rest of it on another day. But so far as caps are concerned, I think it might be too generalised to talk about caps across the piece. I mean, for example, in the CAT, as I had this debate both in the Meta case and in the Apple case a couple of weeks ago, the one that Hannah done yesterday, with the tribunal, in one sense, what you agree in your litigation funding agreements, obviously it sets a a commercial arrangement. But ultimately, what funders get paid in an opt-out case is going to be dependent on what the tribunal say should be distributed on the recoveries. And so, imposing caps may not be consistent with the flexibility that currently exists in the statutory regime. But on the other hand, caps might be beneficial in sort of lower value, consumer claims. I think it needs a lot of thought, and imposing broad brush statutory prohibitions might not be the right way forward.
I think that's fair. I'm just a little bit more cynical about what the government might do to try and get some interesting things done before the election.
And that's uncertainty, and several of the themes that we've discussed this morning are around uncertainty. And I just wonder, as a final point to get the panel's views on, what your impression is of the UK market as a place to invest. I mean, have we done significant damage to the UK market as a place for sort of UK PLC to invest in recent months? Are we capable of fixing that damage and moving forward, or was no damage done at all? That'd be interesting to get your view.
PACCAR isn't the only thing that's happened. We've had Trussonomics and other foot and mouth situations over the last few years. I think it's unfortunately becoming clear that Western European jurisdictions, England isn't necessarily completely risk-free from a legal, regulatory, political perspective. And I think it's important to be reminded of that, that actually that risk premium may need to be adjusted versus what it has been historically.
A good, from my perspective, a good system of redress is absolutely key to a well-oiled and functioning economy, and we have that here in England. And I think the courts have been broadly supportive of litigation finance as an industry and as a tool to bring litigation. I think the Supreme Court was very clear that this was a decision in PACCAR about statutory interpretation, not a policy decision against litigation funding. And we've seen numerous judgments, as Nick has mentioned, and others, that are very much in favour of the importance of litigation funding, bringing access to justice and the like. And I think also the courts have done a good job in opening up other areas in which collective redress can be sought through things like representative actions. So, as I mentioned earlier, we fund a lot of securities actions, and we've started to try to bring those through the representative action regime, following the roadmap that was painted by the Supreme Court in Lloyd and Google as to how it can be done. Unfortunately, the defendant sought to strike out as being inappropriate the way in which it was being brought, and they succeeded at first instance, and we consider that decision was wrong, and we'll be appealing it, or seeking permission to appeal. But I think the highest courts, in particular the appellate courts, are really very supportive, and that helps foster good confidence in our legal system and in our economy and investing in our economy. In those securities actions, we fund a lot of investors that invest in the FTSE 100, FTSE 250 companies. And all of those securities actions are about the importance of transparency from those UK PLCs. And the more that process is assisted, the more that you have a remedy as an investor if something goes wrong because you're defrauded by an investee company, the better it is for the UK economy.
Nick, Neil, any final thoughts on that?
I think I was worried about the decision having a negative effect on, British law UK, so to speak, which we can commoditise around the world. But given where we are now, it looks like we are coming good on this and going to sort it out, which will just maintain and enhance why it is that London is still the centre of excellence in terms of legal procedure and the resolution of disputes. But I have to say, it did early on worry me that as Ellen was saying, I've got examples of parties, renegotiating their terms and moving the seat to Paris and changing jurisdiction clauses, which kind of expected following PACCAR, but hopefully that will be short-lived.
I agree with that. I think PACCAR, in a sense, is the exception that proves the rule. I think it was a self-inflicted wound, but the reaction to it is the thing that proves that this is a jurisdiction that's supportive of litigation finance and supportive of access to justice. And so I think it's a great place to invest as a litigation funder, and I think it will continue to be that way. But of course, the job isn't done. We need to get PACCAR done. I agree with Nick that it needs to be a single clause of forensic change. We need to not get bogged down in some of the wider discussions. But those wider discussions are out there, and questions about regulation, questions about caps, all of this needs to be dealt with. And the industry needs to educate the audience to understand the implications of these things, and that is our best defence, I think, to all of this. That needs to happen in Europe as well. And I think if you were to compare the way this jurisdiction is responding to the way the European Collective Redress Directive has been implemented or not implemented across Europe, particularly in the case of Germany, where it looks to me like it's been implemented in a way deliberately to prevent those claims being brought, I think this does look like a very supportive jurisdiction, and I really welcome that.
Thanks very much. We have a few more minutes for questions, if anyone has any questions for the panel. Just raise your hand. There's some roving mics going around. There's just one up at the front here.
Seems a shame not to have any questions. Andrew Clark with Arbitration Sciences at Emissary Holdings. There's been a lot of discussion about a simple fix, how legislation will be changed. One of the key things about English legislation is it tends not to be retrospective in effect. And if that were to be the case, what does that do to the existing cases which are proceeding? Sorry to throw some banana skin into this discussion, but I think that is a really important
I'll deal with that. So I think the answer to that is the legislation should be and probably will be retrospective. If you look at the amendments that were put into the Digital Markets Bill for the CAT, those were retrospective. The Digital Markets Bill amendments have now been pulled because of the proposal from the MOJ to bring forward legislation. And so if it brought forward legislation that was not retrospective, it would oddly be going back on something that the Digital Markets Bill was going to implement for the CATs. That would make no sense at all. And so no, that's my sense of this, is it will be retrospective. Again, very unusual, massive achievement.
Any more questions? It doesn't look like it for now, so we have a coffee break for the next half an hour, and then panel 3 starts at 11:45. Just like to thank panel members here for an excellent discussion, and see you back shortly.